Hello. Not so long ago, here on the channel, we were discussing a transaction, a document and a sort of contract putting end to a litigation. But before something ends up with a transaction, there should be a settlement agreement. It might be in the course of litigation, it might be well before litigation, in order to avoid litigation. It might be several minutes before the final judgment. There are many points in time where a settlement could be reached, but only then the situation can be resolved with a transaction. So, when we're talking about a settlement, it's sort of clear that not every settlement is acceptable, and a settlement for the sake of a settlement is not a good idea. So, what do we expect of a settlement to call it a good settlement? First of all, well, when there is a settlement, usually there is a conflict behind that, underlying that. And in a conflict, usually, if we are in the legal domain and not some kind of psychological domain, so usually there are more than one person in a conflict, like more than one party. Most often two, but there might be more. And to reach such a settlement, every party, if they don't want to go before a judge who would say, like, final, okay, you're right, you're wrong, or you're right to this extent, you're right to this extent. If the parties do not want to risk that, because it's usually a risk, then the parties just go for some sort of a compromise, meaning that each party gives away something, meaning that each party had something to give away, some claim, some property, some monetary value, some right to a certain extent, some hope, some pretense, some allegation, some accusation, whatever. Because even if a conflict is started by an just unprovoked attack of one person onto another, uh, in an attempt to get something from that person, the settlement, the good settlement, is not one when something is given away to the attacker and that's it, and usually not when nothing is given to the attacker and that's it, but when in exchange for giving away something, uh, a promise, a confirmation from the attacker that there will be no more ever claim about same facts and same situation in the future is taken back. So if the attacker thought, for example, that he might claim, I don't know, $10,000, and the one in defense is ready to give, let's say, 2,000, but under a condition that there will be no ever future claim for the rest of this amount, or like for the same reason to claim this amount. So you see, like, for both parties, there is a certain risk. The one who is giving 2,000, there might be that before a judge, there would be no order to give anything to the attacking party. On the other hand, the attacking party might eventually realize that the claim might be even higher than 10,000 and definitely higher than two, but it's over already because of this agreement, because of this settlement. So if a settlement uh, does not show mutuality of the compromise, then probably it's a precarious settlement, and something is not going well in there. Also, the idea of a settlement, at least in this legal and pre-transaction sense, is to block both parties from further conflict, at least based on the same claims, same facts, same situations, same relationship, which means that usually, even if something was not put into the initial attack, into initial demand, into initial claim, a mutual release is envisaged, at least when you hire a lawyer to draft your agreement. Sometimes in quite precise terms. For example, if the idea was like who has the property right for some piece of land, let's say, and that was the gist of it, and the initial compromise would be about that. But then also maybe on the way there was some expense, and somebody just made some repairs, and somebody just suffered some economic loss because of this and so forth. So if we leave it simply at the question of the land, there might be connected claims against each other after. So the settlement would be not final in a way, and then there will be some ways to become vindictive and to go for some sort of revenge even after the agreement is reached. So to block such an non-productive and not so much useful use, sorry for the tautology, of the settlement agreement as it is envisaged, it's a good idea to put in some mutual release for the claims, the connected claims, for the claims that could have happened, and against not only the parties but against the related persons, sometimes employees, sometimes employers, sometimes representatives, mandatories, insurers, whoever. Uh, anyway, the idea of a release means that from this point, from the point of this agreement, as we agreed on this major thing, we sort of waive any right to go against each other for just smaller connected stuff, something like that. So a good settlement is a settlement that covered all the conflict, like the actual conflict, but the basis, the reasons for the conflict, like as much as possible as well. And also, and here certain legal experience and imagination is needed, also a conflict that might have been, but neither parties so far thought about it. And before it just got escalated, it should be quenched right away by this like mutual release. Of course, a good agreement is the agreement that leaves no questions later about how to interpret it. So it should be as clear, as precise as possible. And in this sense, a verbal agreement is not enough. It should be a written agreement. It should be a written agreement where like free will of each party is clear and usually confirmed by the affixed signature on the document. And if the question is potentially or actually serious, homologation before a court is recommended, meaning that when the agreement is reached, even if there was no court case, but it's possible when the agreement is signed by way of a transaction, which we discussed before, to present it before a judge so that the judge would simply order the parties to follow the agreement as it is. The good thing is there that both parties are more sure about the future of this settlement agreement. The disadvantage is that if the terms of the agreement are really precise, and if there is no stipulation that parties might alter the terms of the agreement by their additional agreement, if there is no such a stipulation, then later, if the parties would want to go that way, it would be against the judgment already, which might have rather unpleasant consequences. So this is it. Usually, it's a good idea to look for a settlement, look for an agreement. But it should not be any agreement. It should be a mutual compromise. It should be mutual release. It should cover all the conflict in its entirety as much as possible. And it should be bulletproof in the sense that it's clear and precise and preferably confirmed by the court. So this is it for today. Thank you and have a nice day.